take your lordship through some of the documents on which the defendant has relied. But kindly remember one thing, that so far as my client is concerned, he did not have any money. But what they did have was the property. Statesman House, 4 acres of land in the center of Calcutta. Now, nobody is charitable enough to come to me and lend me money. And for that matter, not small sums of money. 16 crores, 13 crores, 14 crores, ultimately 134 crores. Now, nobody is here in this world to do charity like that, excepting perhaps, my lord, the charitable institutions which you see. So here, my lord, when your lordship will be considering the facts of the case, kindly remember that one party is coming with the money and the other party is giving, my lord, the property. So the person who is coming with the money, he knows that I have got the cushion to fall back upon. And what is that cushion? That is the property in the center of Calcutta. So, my lord, keeping that in mind, my lord, I will request your lordship to look into this. My lord, I have shown to your lordship the agreement, the development agreement, which is the foundation for the cases of the plaintiff and the defendant. Now, the development agreement makes it very clear that I am the owner, I continue to remain the owner. The defendant is the developer who is going to develop the property. And, my lord, he will recover the money that he has lent and advanced for the purpose of development of this property by, my lord, taking the usufructs or a portion of the usufructs from the property itself when it is developed. So, my lord, the endeavor of both the parties had been to bring, after the development had taken place, to bring somebody or a number of persons who will occupy these premises, pay the amount of money against which, my lord, the amount of loan which has been advanced by the developer will gradually be paid off. So that assurance was there with respect of the property, from the property. If that assurance had not been there, and this is what I am emphasizing, nobody would have come forward to lend and advance that amount of money. Well, now, what happened was this: after the property was developed, both parties were trying to get persons who will come and invest by way of either purchasing a portion of the developed area or, my lord, taking by way of rent. Out of the money that will be recovered, and your lordship is pleased to see, 52.5% would come to the owner and 47.5% will go to the developer. This was what was agreed upon, and both parties were happy with this situation. And your lordship will be pleased to see that throughout, whenever money was lent in advance, the enormity of the advances which is being projected before your lordship, kindly do not look it in isolation. Kindly link it up with the property. So a person is coming forward and advancing money. What is he getting out of it? What he is getting is the promise of, my lord, having a portion of the revenue which is being earned by letting out the developed portion of the property. That was the thing. That is, keeping that in mind, well, that Mrs. Gujral was brought in, who went away because of some allegations which had come against, my lord, the developer. 2 other persons came in, Zoom came in, Bhattar came in. I shall show to your lordship. And that is, my lord, for that purpose, I shall draw your lordship's attention to the affidavit in opposition.
So,
Where, my lord?
that was prior to the minutes of meetings, that is 10th March.
Yes. 10th of May. The minutes of the meeting of 10th of May. My lord, prior to that, my lord, all these things happened. They came, they went. Amount of money was advanced. A loan agreement was entered into. And all these things were done with the consent of the parties. I am just asking this question to myself. Why should a person, my lord, get into that kind of involvement with regard to that amount of money? Unless, my lord, he had some kind of an assurance that we'll get it back. My lord, keeping that in mind, my lord, I will request your lordship to take their affidavit in opposition. This is in GA1. Will please to come straight away to paragraph 30 at page 10. Well, kindly come to para 30.
Yes.
After paragraph 29, 2nd December 2019, my lord, commencement of work. Then para 30. In the meantime, sorry, my lord. Page 10, para 30. In the meantime, in or around July 2019, kindly see on 2nd December 2019, the commencement of the work started. Notice was given para 29. Before that, in the meantime, around July 2019, the petitioner requested the answering respondent to arrange a loan of a sum of 16 crores. In order to keep the business relationship harmonious, and since by then the enormous investments had already been made by the answering respondents in the project, the answering respondent arranged for an interest-bearing loan for a sum of rupees 16 crores from Zoom Banijjo Private Limited. Copies of the agreement annexed here too. Now I pause here for a moment. I ask a person that give me 16 crores of rupees loan and he advances the money to me. It is not by way of charity. He looks into what I have got by way of security, whether I will be able to recover this amount of loan. So what he does is he gets hold of, my lord, the Zoom Banijjo for the purpose of investing this amount of money. In addition to the amount arranged from Zoom Banijjo Private Limited, a further sum of rupees 3 crores 17 lakhs was retained by the petitioner as a loan from Bhattar Projects Private Limited. Bhattar Projects Private Limited has entered into an agreement for sale dated 10th March 2021 for being allotted 5,500 square feet of the said premises. So, my lord, these persons are coming, my lord, like, if I may use the expression, like bees, my lord, coming to the beehive for the purpose of, my lord, enjoying, my lord, whatever is available, the honey. So they are coming for the purpose of, my lord, investing the money in the property. So my property, which was there in the center of the town, that was the attraction. So then, however, subsequently, the agreement for sale was cancelled on 9 July 2021. A copy of the letter dated so and so is annexed here to marked letter L. If your lordship, my lord, kindly comes to page 93 of the same volume. Just see, my lord, the letter. Page 93, annexure L. This is to place on record that by virtue of a sale agreement dated 10th March 2021, we, along with Merlin Projects developer, have jointly agreed to sell to you the commercial space measuring so and so on the second floor of Statesman House for a total consideration of rupees 6 crores 5 lakhs. Out of the payment made by you to Merlin under the agreement, we have received from Merlin Projects a sum of rupees 3 crores 17 lakhs towards our share of the revenue out of the said sale. So, my lord, this amount was given to us by way of, my lord, 52.5%, as was agreed between the parties. It was paid to us. As discussed with you and the developer, that since the building is under construction and it will take some time to complete the same, it has been agreed that the said payment received by us through the developer shall be treated as a financial loan refundable by us together with interest at 20% to be calculated from the date of receipts of the said amount on quarterly compound interest basis till the date of repayment. Upon such repayment, the arrangement for the sale of the space stand cancelled. We will make the repayment, etc. in 5 installments. Now, my lord, this is what, my lord, with the Bhattar projects. So these were all, my lord, the transactions which were going on when the property was coming up. And
Sir, you were also party to it.
yes, of course, I was a party to it. I was a party as the owner. Developer was a party as a developer. And both were, my lord, proceeding on the basis that I shall get 52.5, he will get 47.5. Now, my
Did
lord,
you
kindly,
ultimately refund this amount?
yeah, my lord, what happened, I shall tell your lordship afterwards. Then, my lord, kindly come to paragraph 11, page 11, paragraph 32, I was there. Upon cancellation, a sum of fees 3,71,000, etc., has been, which had been paid by Bhattar Projects Limited in terms of the agreement for sale, was required to be refunded, along with interest as mentioned therein. While the answering respondent returned the share, the petitioner was not in a position to do so and was not desirous of doing so. At the request of the petitioner, the answering respondents convinced Bhattar Projects Limited to enter into a loan agreement with the petitioner for the said sum of rupees 6 crores 11 lakhs and 7,000, which included interest calculated till date of the agreement. Copy of the loan agreement is annexed here too. Then loan agreements were executed between the petitioner and the answering respondent. The petitioner and Zoom Banijya Private Limited and the petitioner and Innocent Merchandise Private Limited, all dated 10th May 2024, copies whereof are annexed here to collectively marked. Well, these are all persons who are interested in investing. There's nothing great about it.
Different portions.
Yes, in different portion of this constructed area. In addition to Zoom Banijya Private Limited and Bhattar Projects Private Limited, on the request of the petitioner, the answering respondent had also lent a sum of rupees 19 crores to the petitioner between the period 2nd July 2021 and 12 July 2021. Details whereof will appear from answering respondents' bank statements, copy whereof is annexed here too. Thus,
entities are related to money.
well, all these, well, I should show to your lordship, all these entities were related to Merlin. And well, they have arranged this amongst themselves. The situation of the petitioner was such that its numerous creditors and workers and employees were taking coercive measures against it. I crave leave to refer to the documents regarding it if necessary. Then para 36. It is in the above circumstances the answering respondent had agreed to lend the aforesaid sums. These sums were used by the petitioner for repayment to its creditors. In addition thereto, therefore, my lord, what is happening is this amount of monies are being advanced from time to time by the developer. Property is being developed, and my lord, the expectation was this, that out of the share that they will get this 47.5%, these amounts will be paid, and my lord, some additional amount will also be recovered. Then, in addition thereto, the answering respondent had also paid on behalf of the petitioner.
No, sir, with Zoom Vanijya, it failed.
Yeah.
What about the others?
Bhattar.
Yes,
Bhattar, my lord, went out.
It was successful.
No, it was not. They, my lord, went out, they, my lord, backed out. As I showed to your lordship, my lord.
Then there's another one.
Zoom.
Innocent Merchandise Private Limited.
They, my lord, came in and Innocent Merchandise. I shall tell your lordship, my lord, let me take instruction and come back to your lordship. These are all persons who are interested in investing money in this particular property. In addition, there to para 37, the answering respondent had also paid on behalf of the petitioner various sums due and payable by the petitioner on account of unpaid Kolkata Municipal Corporation taxes, outstanding electricity dues, and shifting expenses of the petitioner's office from the third floor at the said premises to ground floor and back again to the third floor, as the petitioner was unable to meet the financial liabilities. These expenses were to be refunded by the petitioner together with interest to the answering respondent, which has not been done till date. The answering respondent craves relief. Then, when the answering respondent has assisted the petitioner in obtaining financial assistance, as mentioned above, only to ensure that the petitioner discharges all its obligations as per declaration dated 26 March 2019, as also all other statutory dues and other liabilities of the petitioner. However, the petitioner, even after receiving all the monies which were advanced by the answering respondents, as also arranged from the third parties, the petitioner did not discharge the dues. As a consequence thereof, the answering respondent continuously faced obstruction and hindrance in the progress of the work. The answering respondent discovered that there were numerous outstanding issues which remained between the parties while the work was continuing, unabated. With respect to the area to be occupied by the petitioner for their own office, there were unresolved issues. Further, the project was soon approaching a stage where there would be marketing and large-scale realization of revenue. So, my lord, this was the anticipation. So, this is what they are saying. Further, the project was approaching a stage where there would be marketing and large-scale realization of revenues. This is, my lord, the attraction which was there before them. That is why they were advancing monies. The petitioner had already started avoiding any discussion with respect to repayment of the outstanding loans to the answering respondent and other entities which had lent monies to at the instance of the answering respondent. The petitioner has also only made part payments of the repayment of the loans of Zoom Banijya Private Limited and Innocent Merchandise Private Limited.
So with Innocent Merchandise Private Limited also it did not materialize.
Yeah, ultimately, yes.
Loan was granted. However, it
Well,
did not ultimately fructify.
Yes, well, what happened is this. These entities were entering into agreement with us for the purpose of, my lord, having a portion of this developed property. So money was advanced for the purpose, ultimately for the purpose of satisfying, my lord, the dues that will generate by reason of their possession of the property in different portions. In these circumstances, the answering respondent and the petitioner held a meeting on 20th April 2022 and agreed. Well, I will request your lordship to come to page 114. What was agreed upon, your lordship will find from the agreement itself at page 114. This is in the form of a supplemental agreement. This agreement made in Kolkata 6th day of July 2022. My lord, Statesman is the owner and my lord, Merlin as the developer. My lord, whereas the owner and developer had entered into agreement, I'm not troubling your lordship. This said agreement, that is the development agreement. Certain financial arrangements were arrived at between the owner and the developer subsequent to the said agreement, whereby the developer advanced and arranged to be advanced certain sums of money to the owner. Further, certain differences between them had arisen between the owner and the developer subsequent to the execution of the said agreement. The owner and the developer had, in the spirit of harmony, come to certain decisions at the meeting on 20th April. What are the decisions? It has been decided between the parties that they will share the net sales revenue and or areas, sales revenue and or areas of the existing Statesman House and the new building, only in that, under construction in terms of the said agreement, that's the development agreement, save and except the area already said sold to Bhattar Properties Private Limited by the owner and the developer, more fully mentioned in third schedule, to be retained exclusively by the owner, more fully and described in the fourth schedule. Then your lordship will please to come to the next page. That's said that the
And the
devil.
said areas will be outside the purview of net sales revenue or sharing areas between the owner and the developer.
Yes, the area which one.
Portion had already been sold to Bhattar Projects Private Limited.
Well, this is an agreement for sale, not sold really.
But then,
And that was the one that was cancelled. Your lordship has been pleased to see. So this was an agreement which was entered into.
but then it says, sir, save and accept the area already sold to Bhattar Projects.
Yes, yes. At that point of time, that was the already sold, meaning thereby an agreement for sale was entered because the property was not developed at all. At that point of time, it was being constructed. And these parties were coming for the purpose of taking different portions of the property. As it happens, my lord, when a multi-storied building is constructed, the persons will be buying, my lord, different areas. They buy the property, they enter into agreement for sale, pay, my lord, advance money for the purpose of booking that particular area. And when the construction is made, the entire amount of money is paid, conveyances. Well, this is exactly what happened in this case also. A certain sum of money was advanced, and that was when it was cancelled, it was agreed that it will be refunded.
Cancellation ta paben, page 95, whereas subsequent to seeing the building.
And my lord, I've shown to your lordship that there was a letter. If your lordship kindly comes back to page 95,
95.
your lordship has seen at page 93 the
Yes.
letter of cancellation,
At
and
95,
at page 95, my lord,
loan agreement holo the recital e dewa ache, it was cancelled.
your lordship sees, my lord, at page 95, the penultimate paragraph on that page, paragraph 1, 2, 3, 4, fifth paragraph from the top. Whereas subsequent to execution of the said sale agreement, since the building was under construction and the completion would take some time, it was
Yes,
mutual.
in page 95,
95
paragraph,
fifth paragraph.
fifth paragraph.
Yes. And this is really what has been reflected in the letter which I have placed before lordship. It was mutually decided that said sale agreement dated so and so shall be treated as cancelled, and the entire amount received from Bhattar shall be refunded as financial loan carrying interest at the rate of 20%. This is what, my lord, the letter says also. And this is what also at page 115, if your lordship comes back to that. This already sold to Bhattar project is not the agreement for sale was entered into, and that has been recorded. Then your lordship will please to come to page 116. This is with regard to the amount of money which is, these money transactions were going on, my lord, on the basis of, in the background of the property which was there in existence. Then, my lord, para 4, in partial modification of the relevant clauses of the said agreement, that is the development agreement, the owner and the developer will jointly decide all aspects of planning. Kindly note this. Will jointly decide all aspects of planning, sellable super areas, calculations, size of sellable units, marketing strategy, type of mall, rates, marketing and terms of payment in respect of the project. At the meeting on 20th April 2022, the developer had agreed to prepare marketing plans, 3D presentation, etc., and commence marketing of the project tentatively by 31st July 2022. Because they may not anticipated that the building will be constructed by that time. It is now agreed that the owner's share of the net sales revenue will be appropriated, disbursed, adjusted in the following manner. 50% will be adjusted first for repayment of the existing loan together with applicable interest as more fully and particularly mentioned in the second schedule till its repayment, and thereafter towards repayment of interest-free deposit under the said agreement and mortgage agreement dated 26th March 2019 to the tune of rupees 20 crores. And the remaining 50% will be paid to the owner subject to the deduction of tax at source. Now, my lord, pause here for a moment. So what was the agreement? Kindly see, my lord, at when the money was being advanced, at every stage, agreement was being made as to how this money is going to be repaid. Without that agreement, my lord, I mean, not to speak of Merlin, nobody would have agreed to, my lord, enter into these loan transactions with these big amounts of money. So what is being said here is this, that if you get X percent as your 52.50% of the revenue, then out of that 52.5%, 50% will be appropriated by me, the developer, towards repayment of the loan, and 50% will be given to you. So I will not get 52.25%. This was the agreement which was sought to be recorded in this document. What is the validity of that, my lord? I have got my own doubts. But then again, my lord, this was what was mutual.
You have been a party to the
Yes, I have been a
transactions
party,
till
but my lord, kindly see, this is something, my lord, it's a point of law. If you enter into a registered document, then that registered document cannot be modified, cannot be altered, cannot be amended, cannot be abdicated, cannot be completely scrapped without a registered document.
But this supplementary agreement had been a
No.
registered document.
No, it is not a registered document. But anyway, what I am submitting to your lordship is this. I am not taking this point now. What I am submitting to your lordship is this. The parties were at arm's length, sitting across the table. One party was advancing the money with the assurance that there is a property against which I can proceed if the money is not paid. And the other party is saying, very well, I am to get 50% of this amount. 50% of that amount you take and appropriate it towards your loan. That was the mechanism which was agreed to by and between the parties.
Consensus was everywhere.
The last sentence of that paragraph, and the remaining 50% will be paid to the owner, subject to the deduction of tax at source. So out of 52.5, which was the share of the owner, 50% will be appropriated and 50% will be paid. Once the aforesaid two adjustments are made, the further amounts on account of receipts of the owner's allocation shall be paid to the owner, save and aside an adjustment of the balance interest-free security deposit amounting to rupees 10 crores, which shall be made from the final tranche of payment. So this 10 crores also will come out of my share of 50%, 52.2. Then, my lord, para 17, the para at 117, subparagraph C, that after repayment of the loan and interest-free security deposit in full by the owner, including the last tranche of rupees 10 crores, thereafter the owner and the developer may mutually decide to share the unsold areas and unsold parking slots, if any, in terms of the said agreement and of this agreement. My lord, I pause here for a moment. So, my lord, at least your lordship sees at on this date, which is, my lord, the 5th of 6th July 2022. At that stage, at least, the parties were, I should say, the respondent, the defendant number one, was fully conscious of my right in the property. They never thought in terms of my. Today, what is the dispute?
These agreements elicit that you had been in a consensual.
Yes, consensual mode, it was there. I am not going to, my lord, question that for the time being. What I am submitting to your lordship is this. At least up to 2022, the parties were ad idem that this property belongs to me. And the right of, well, the developer is only with regard to his share or in the revenue sharing. What was agreed between the parties at that time was this, that notwithstanding the fact that the parties agreed that 52.5% will come to me for the purpose of repayment of the loan, 50% of 52.5 should be appropriated for the purpose of repayment of the loan. So, Maharaj, it is not that they are completely bereft of this. The parties are at, Maharaj, today, Maharaj, again I come back to it. I'm sorry, Maharaj, to have to repeat this.
Whenever you were in distress, they brought someone or the other.
Yes, and my lord, agreement was made as to how this person who is coming forward is to be repaid back. My lord, today, what is the dispute? Dispute before your lordship is, I am crystallizing the dispute. Dispute is this: a property belonging to me, admittedly belong to me, nobody is disputing that. That property has been sold. That property has been sold to a third party. Number one. Number two, the property has been sold without my consent, without my knowledge. Number three, the person who has sold it as power of attorney holder. Number four, the person who is disputing that sale, he is saying, I have not given you this power. So, my lord, ultimately the question comes to this. You look into the development agreement. You look into the power of attorney. Find out as to whether the power of attorney gives them the power or the development agreement gives them the power to sell my property. If it does not, then, my lord, I am entitled as a matter of right, my lord, the injunction which I am praying for. I am saying that this particular property could not have been sold by. So, my lord, your lordship will to look into these documents, and I showed to your lordship, my lord, how this has been dealt with in this affidavit in opposition. My lord, kindly come back, my lord, to the paragraph which I was on.
117, page number 117.
Yes. Now, my lord,
paragraph C.
kindly come back to page 14, paragraph 41. The parties, kindly, these are very important paragraphs. Para 41.
Yes.
The parties discuss the mode and manner of alienation of the said premises at the meeting held on 4th April 2023. Your lordship will have to look into the minutes as to whether there was an agreement to alienate the entirety of said premises. And the 5th April 2023, attended by Rajendra Prasad Gupta, the chairman, and Ravindra Kumar, the managing director of the petitioner. Copies of the minutes of the meeting of the 4th and 5th April 2023 annexed here to letter Q. Kindly come to page 120. And I shall come back to this paragraph after, my lord, I have shown your lordship page 120.
Yes.
MOM, minutes of the meeting, dated 4th April and 5th April. The presence has been recorded. Mr. Sushil Mota and Vishal Jain on their behalf, and Rajendra Kumar Gupta and Ravindra Kumar, my lord, on behalf of the statesmen. Various options were discussed. Options discussed were lifestyle mall, rental model, then later to be sold to some HNI as one unit or state or starter sale model, or as is where is sale model of the entire structure. So parties were discussing this, and this was in 2023. Mr. Gupta has conveyed that he will prefer the starter sale model. I don't know what to explain of shops to have immediate cash flow, because he needs cash flow to clear the liabilities of investors through Merlin as interest is mounting, and also his own needs. Mr. Kumar and his team will start market research for concepts of the mall starter sale model.
Unit wise.
I see. I am told the starter sale model means unit-wise sale, and will come back soon. Mr. Mota has given one option of exiting immediately. Kindly note this. Mr. Mota has given one option of exiting immediately if any buyer wants to take over the entire development as is where is condition, and can offer him a sum of around rupees 100 crores plus amount paid to statesmen by Merlin Group as well as by the investors with interest as agreed. In fact, he was ready to give discount provided down payment and immediate closure of the deal within April 2023. Mr. Gupta has also conveyed that he may go for a lifestyle model if any buyer comes and offers him an amount equivalent to his expectation. And
Without
this,
completing construction, Mota is now
yes,
trying to
no, my lord, at that point of time, my lord, the construction was not complete. My lord, the completion certificate came much later. It came in 2025, completion certificate of this. This in 2023, my lord, the developer was having problem, The developer was saying, I want to exit if, my lord, somebody comes and pays these amounts of money. Now, this MOM was, my lord, controverted at page 121 by, my lord, Mr. Ravindra Kumar, who was the managing director of Statesman. And he pointed out as to what was actually discussed and, my lord, the modalities of it. And ultimately, it did not matter. But then again, my lord, kindly see that at every stage, parties were talking and parties were coming to a conclusion as to what is to be done in future with regard to it. The parties were at arm's length, sitting across the table and settling the problem. This is what I am insisting on. I am, my lord, going on emphasizing that the parties were, my lord, this is a development thing. It can't be, my lord, one fine morning you wake up and sell off the property. This is not one of those things, chocolate or, my lord, a pencil or this thing. And this is exactly what it is. This discussion is there. I'm not going to trouble your lordship with this. There has been some amount of controversy and said that, no, this is not what was agreed. It was something else was agreed. And that was being recorded here. And, my lord, kindly come to this page 121, the last three paragraphs, 8, 9, and 10. Mr. Mota had in past time and again mentioned that he was ready to exit the project if he received his cost plus reasonable interest, on which he may give some discount. At the previous meeting, he had said he would revert on the issue after consulting with his family. At this meeting, he said that he could exit for a consolidated figure of rupees 140 crores with some discount, which included cost of the project, initial advance, and investment public Merlin funds given to statesmen as deposit and loan. Mr. Gupta had said that he will try and see if he can identify a buyer. Then 9, you presented some number on estimated values based on lease rental investment projections. Mr. Gupta said he would exit the project if the return received met our expectation. The next meeting fixed for in the following week, when we would meet to discuss all options. It was also decided that Mr. Kumar would make inquiry about different options and revert at the next meeting. Now, my lord, kindly come back, my lord, to this. So, my lord, this is all at the negotiation stage, discussion stage, and, my lord, the parties were all the time discussing and, my lord, coming to some kind of a conclusion with regard to how to handle this problem. Then, my lord, page 14, para 41, which is also very important. Yes, this I have placed before lordship, 4th and 5th April 2023 meeting, the minutes. Then the para 42. The petitioner thereafter by an email dated 14th May purported to record his own version, which I have placed before lordship. Then para 43. Parties continued to deliberate, but ultimately there could be no buyer obtained for the purpose of transfer of the strata or earlier or entire shopping mall. This was the situation in or around 2021, which continued till the recent past as stated hereinafter. But this is not quite correct because your lordship has been pleased to see the discussion which has taken place in 2023. The last discussion which your lordship has been pleased to see. The petitioner thereafter, sometimes in November 2023, introduced, my lord, this is what I am pleased with your lordship, introduced one Shalini Gujral. So it is an admitted position that in terms of that letter which was written by Mr. Kumar, the petitioner obtained this Ms. Shalini Gujral, who apparently was interested in buying out the entire project. This is what, my lord, we obtained. A MOU was executed at the behest of the respondent with the said Shalini Gujral. It soon became evident that this was a pure ruse, since Shalini Gujral completely disappeared from the scene without any intimation. This is wrong. I have shown to your lordship the reason why Shalini Gujral.
For an explanation.
No, Shalini Gujral, your lordship will please to remember, had made a complaint. Petition. She had made a complaint that after I have entered into this agreement, I came to know two facts. which was suppressed from me. First is this Axis Bank had given a loan of 50 crores in respect of this property. That was not told to me, number one. And number two, that the ED and my lord CBI had proceeded against my lord Mr. Mohta. So she said that this kind of a disputed thing, I am not going to get into it. And I've shown your lordship that the letter before lordship. This is at page 229. Your lordship can make a note of it. Page 229 of the petition, where my lord, she says that I've discovered certain shocking information which was neither disclosed to our clients by Mrs. Merlin Projects Limited or by you. So, and thereafter had enumerated these reasons. First reason, my lord, is as I told your lordship, this loan. And number two, my lord, the ED and CBI going after them. So, my lord, that is the reason. So, para 44 is that. This is not correct. Para 45, kindly see. Petitioner had represented that Shalini Gujral could not arrange necessary funds. And since she was close to petitioner's principal officers, and particularly Mr. R.P. Gupta, the matter should be laid to rest. Where it was obtained from, I don't know. The petitioner now relies upon a document allegedly issued by a learned advocate on behalf of the Shalini Gupta to incorrectly assert that she backed out of the transaction in view of criminal investigation pertaining to respond number one. This is partially incorrect. This is totally incorrect, since the respondent number one enjoys an extremely good reputation in Kolkata. I'm not going to question that now, before your lordship. I am not interested. Never had this been brought up as an issue during the time when the exit of Shalini Gupta was discussed. It was also wrongfully asserted by the petitioner that the said premises had been allegedly mortgaged by the respondent number one for its own benefit, which assertion is incorrect. Well, I don't know what it is.
Correct বলছো তো? ওই যে 50 crores loan নেওয়ার কথা ছিল for the project, they are admitting they have taken the loan for Statesman House and another project, Ibiza. So my property was mortgaged for taking a loan from Ibiza.
Page
230 of the petition.
Well, I have shown to your lordship page 230 of the petition. Kindly, my lord, come to page 230 of the petition. My lord, it is becoming curiouser and curiouser.
This is the explanation they gave in response to Shalini Gujral CA, that 50 crores have been taken. And the loan.
Well, this is the letter. They say that this was not brought to their notice. But, my lord, page 230, this Vishal Jain is writing on 19th December 2023. Your lordship kindly sees this. The first note on loan. Total loan sanction amount of rupees 50 crores from ICICI Bank on Statesman House and Ibiza Resort combined, out of which till date we have withdrawn rupees 35 crores only. So, my lord, on the basis of Statesman House and Ibiza Resort combined, my lord, and this title deeds were showing that this title deeds, my lord, this amount of loan is being obtained. So, my lord, how are they saying in para 45 that this was something which was not brought to their notice? This is, my lord, the letter of Merlin's letter to us, and admitting that this is what has happened and this has not been shown. Kindly see, my lord, petitioner now relies upon a document allegedly issued by the learned advocate on behalf of the Shalini Gupta to incorrectly assert that she backed out of the transaction in view of criminal investigation pertaining to respond number one. Yes, this is what it has been written. This is totally incorrect. Enjoys an extremely good reputation. Then, my lord, kindly come to para 46. My lord, each paragraph is important in my very respectful submission. Para 46 at page 15. Sometimes in and around April 2024, Stop expressed interest to the answering respondent for obtaining a part of the said property on lease and issued an email dated 19th April 2024. This email was made over by the answering respondent to the petitioner on 22nd April 2024. The petitioner's managing director, however, surprisingly, did not agree to leasing out the spaces to prospective tenants as is recorded in his email dated 22nd April 2024. Copies of the email dated 19th April 2024 and 22nd April are annexed. Well, this is at page 123.
So therefore, my agreement was necessary.
So, Malad, the point is this, that at every stage, they had been consulting us. It is not that I have got a power of attorney from you. Therefore, I don't have, on the strength of the power of attorney, I can enter into transactions without reference to you. That is not the case. Page 123, I can't read it, my lord. It is.
Yes, sir. An initial offer from Shoppers Stop for Statesman House. If we negotiate, it can improve further.
এত ছোট লেখা কিছু পড়তেই পারছি না।
They are seeking your negotiations.
Yes.
They are seeking my permission, which is the crux of development.
Throughout, my lord, they are seeking. And as I told you, lordship, the issue is, would they have sold the property without reference to me? Then, my lord, kindly come back to para. Yes, my lord, kindly come to para 47 at page 16.
Yes.
The answering respondent and the petitioner subsequently held a meeting on 10th May 2024 and had reached an agreement, the terms of which have been recorded in a document dated 10th May 2024, which has been signed by both the parties. A copy whereof is annexed here too and marked with the letter T. I have placed it, I shall place it again. A further document being a loan agreement was executed by the petitioner and the answering respondent on the same date, that is 10th May 2024, wherein the petitioner admitted its liability to pay the answering respondent a sum of fees 33 crores 18 lakhs 95,754 inclusive of interest. Well, nobody is disputing that this, whatever is the amount is due and payable, is liable to be paid. My lord, kindly come to page 125. This is, my lord, page 125 is the minutes of the meeting. Your lordship remembers. This is what I placed before lordship. Here, my lord, the only thing I just reiterate before lordship, after recording the amounts which are loan amount, my lord, which they say it's 33 crores and odd. Then, my lord, it says, kindly come to page 126, subparagraph C. Subparagraph C and E. I am going to, my lord, just reiterate these paragraphs once more. Subparagraph C. Because I tell you, lordship, why I am emphasizing on this. Because this is the document on which, my lord, they have relied for the purpose of sustaining their case.
Yes. If
In the
you
event
fail to fulfill the commitments,
Yes.
they will be automatically entitled to dispose the project in its
No.
entirety for recovery
dispose of the project in its entirety, not the property. Dispose of the project. Project means, my lord, what is being constructed. That means, my lord, what it says is this. What is sought to be, my lord, emphasized on is this, that by this agreement, statesmen had agreed that entirety of 52.5%, which they were entitled to by way of, my lord, sharing of the amount between the parties, the entirety will go in their pocket. Very well. If that is so, that is so. Not the property. It is my entitlement to that. My share in the project only. In its entirety for recovery of all its use at its sole discretion and in any manner whatsoever, without any reference to the owner, and the owner consents not to raise any objection whatsoever with regard thereto, and also extend necessary cooperation to the developer in this regard. And in turn, developer will act. My lord, if
But then you were not given the opportunity to extend cooperation.
but I don't understand two things. Kindly see the contradiction. There's a without any reference to me, to the owner, this will be done. And I am to extend necessary cooperation to the developer. If they can do it without reference to me, they don't need my cooperation. Whether I cooperate or not cooperate, you sell my my share in the project.
Therefore,
Full.
they stuck to the first proposition, and without referring to you, they have done it on your failure.
What has they done? Sold the property, not the project. If they sell, my lord, my share in the project,
Property inclusive of the project.
no. Well, yes, property includes the project, but the project does not include the property. This is, my lord, the confusion that the appeal court did, which, my lord, was, my lord, set aside by the Supreme Court. The developer, and at its discretion, would be entitled to deal with in any manner the entirety of the project. Again, my lord, kindly see the project. To any one or more purchaser, oblique, lessee, or the like of his choice. Well, I ask this question to myself: a purchaser or a lessee of the project. That means, my lord, insofar as the project is concerned, I sell the whole one whole floor to Trent. I sell the whole floor to, my lord, Shoppers Stop. That you can do without reference to me. This is what is being said here. I say that that is contrary to, my lord, the registered document. But let us assume for the sake of argument that this could be done. What is it? It is confined to that. Could you have sold my property?
Shoppers Stop and West side are the same.
No,
They
no.
mentioned about the West side.
After the minutes, West side came.
So
Shoppers Stop went out.
Shoppers Stop was never.
Ultimately, well, Shoppers Stop didn't come in. West side came in.
And that's the
And that is the
paragraph,
trend.
the paragraph.
Then, my lord, kindly see that subparagraph E. The title deeds of the Statesman House, situate at 4. My lord, kindly see, my lord, this paragraph will clinch the issue. The title deeds of the Statesman House, situate at 4 Chaurangir Square, has been deposited by the owner, namely the Statesman Limited with Merlin Project Limited, on 26/3/2019, pursuant to registered mortgage deed dated 26/3/2019, creating charge on the property to secure all monies that are due to the Merlin Projects Limited. Now pause here for a moment. Kindly see, a distinction is being made between the property and the project. I am going on emphasizing on that. Project is, my lord, subparagraph C. Property is subparagraph E. It is agreed between the owner, again, owner as mortgagor, and its directors, and the Merlin Project Limited as mortgagee, that the title deeds would lie deposited with Merlin Projects Limited, and that Merlin Projects Limited would be entitled to retain it, not transfer it, retain it till the entire dues, that is the amount stated in A, B, and D above, and other dues of Merlin Project Limited is repaid. However, if the owner fulfill its commitments of payment of rupees 55 crores to the developer and approach the developer for release of the title documents for availing of financial assistance to fulfill its further commitment of payment to the developer, in that event, the developer at its sole discretion may hand over the title documents to the concerned lender directly to enable the owner, that's myself, the statesman, to avail such financial assistance with the condition that the same should be exclusively utilized for liquidation of the owner's liability. Well, what does it mean? If, my lord, the title deed documents, my lord, if I may respectfully put it this way, that if you sell a property, the title deeds will go to the purchaser. If I sell my property to a purchaser, the title deeds will have to be handed over to the purchaser.
So
He
this
will
is
be
a
the
provision for your assistance.
Well, so here, what is said here is this: the title deeds should not go to anybody. It will be retained by me. And not only that, title deeds will be handed over to me. How can, my lord, title deeds be handed over to me by Merlin if Merlin sells the property and somebody else is...
No, but then this portion, sir,
Yes.
from however
Yes.
till liability towards a developer, it seems that they are keen to assist you in case you were in a position to obtain loan from somebody else.
Then they will
Then they would transfer the title deeds in their custody to the person who intends to lend you money.
My lord, this is exactly what it is. Now, if this is so, this completely militates against the concept of selling the property and handing over the title deeds to the purchaser. If the Merlin could hand over the title deeds to me if I needed money, if I could raise money, then my lord, Merlin is agreeing that they will hold on to these title deeds so long as I am able to, my lord, repay the amount of money. This has to be so because Section 69 of the Transfer of Property Act says that this is an equity of redemption. I have got a right. The mortgagor has a right in respect of this property, and the mortgagee is obliged to give, my lord, that particular benefit to a mortgagor. That whenever, my lord, mortgagor wants to come forward and say that I want to pay you the money, give me back my title deeds, the owner is the mortgagee is obliged to hand over the title deeds. He cannot sell and completely defeat my right, and this is what he has sought to do. Handing over of the documents of title, meaning thereby that the documents of title will be with them, with Merlin. It will not go to somebody else, X, Y, and Z. Now, my lord, Hatishala is, my lord, holding on to the. How do I get back my title deeds? Supposing I say that I want to pay you off the money. This can't be done. A notice is required. If you want to enforce the mortgage, you have to give me a notice, 3 months notice for me to get hold of the money from the market. And within 3 months, if I pay you off the money, you are obliged to return me my documents of title and get the property free of mortgage. So this was, my lord, kept in mind. This particular document in my respectful submission militates against, my lord, their contention that I am entitled to sell the property to Hatishala. Then, my lord, this along with that, your lordship will be pleased to come back, my lord, to the, yes, affidavit in opposition. They have said that an agreement was entered into also, page 128. That agreement is also important. That is dated. Lordship will please to come to
10th of May,
yes, 10th May, the same day
on which the meeting took
place. An agreement was entered into. This agreement,
Does it include the context of the meeting?
it is in the context of the meeting because on the same day it was executed. So, my lord, this is your lordship will kindly see this. Here, the Merlin has become the first part, and it is being described as Merlin. The Statesman Limited is the second part. Then, my lord, kindly come to page 130. He's recording, my lord, the amount of money that has been lent in advance.
So now this agreement is in part supersession of the supplementary agreement dated 6th of July.
5th of July 2023. 2022. And whereas, kindly note, the first part at page 130, first paragraph is recording the amount of loan. And then, my lord, second paragraph is also recording the financial assistance they had rendered to the extent of 33.18 lakhs. And whereas the parties agree that this agreement is in part supersession of the supplementary agreement dated 6 July 2022. And whereas, my lord, this is a very important paragraph. And whereas the parties here to have agreed to record the terms in writing as recorded herein, and this agreement is the only outstanding agreement between the parties with regard to the, kindly see what? Aforesaid financial transaction, and without in any manner affecting the registered agreement of development, registered power of attorney, and registered deed of mortgage. So, my lord, keeping them alive, my lord, this particular agreement has been entered into, only recording, my lord, the loan. Everything, my lord, is intact. Then, my lord, kindly come to page 131. Now, this agreement witnesses and it is agreed between the parties as follows. It is agreed and recorded that the Merlin has given financial assistance to aggregating rupees 19 crores out of the aforesaid loan of rupees aforesaid, the loan of to which 10 crores 75 lakhs will carry interest at the rate of 20%, and 8 crores 60 lakhs will carry interest at the rate of 15%. Then statesmen will make payment of all TDS together with interest to the authorities on or before 15 July. The aforesaid loan will be repayable, inclusive of interest, by the statesmen on or before 15 July 2024. This date of repayment is final and binding on the statesmen and not extendable under any circumstances. So, my lord, I continue to remain a debtor by reason of this particular document. Nothing else is being, it is only financial amount, the amount of loan that has been recorded, the interest payable has been recorded, and keeping, my lord, most importantly, all these documents intact. The development agreement, power of attorney, and my lord, deed of mortgage. And thereafter, my lord, kindly see the completion certificate at page 133, which they have disclosed. This is dated 14th May 2025. So, my lord, up to 2025, my lord, the construction was not complete. This 14 May 2025, the Calcutta Municipal Corporation had given them this certificate. Year date kabe? Train tape?
6th of March 2020. 6th March 2020.
And my lord, on 5th of March 2025, 6th March 2025, the agreement with Trent was entered into, which your lordship has been pleased to see, which clearly records, my lord, that I continue to be the owner. I continue to have this 52.5% share. I continue to, I am liable for the repayment of the loan, and the repayment of the loan will take place by appropriating the entirety of 25%. I will not get anything until the entire loan is being repaid. So, in 2025, in the month of March, no? In the month of March, my lord, if my lord, my title to the property is recognized, notwithstanding, my lord, the power of attorney, the question arises, how on the strength of the power of attorney they are entitled to. 2 paragraphs I just wanted to draw your lordship's attention from my lord. This is very cleverly drafted. I congratulate my learned friends, my lord, the lawyers who had drafted this. My lord, kindly come to the paragraph, my lord. What they are saying is this, and this is what they are saying: we are justified in selling this property, and on what basis they are saying so. My lord, kindly come to paragraph 58 at page 18. Page 58. The answering respondent had thereafter proceeded to transfer the said premises. So, my lord, they are now saying that we are justified in transferring the premises, except the area retained by the petitioner for their office to the respondent number 2 on 27 June 2025, being permitted to do so in terms of, kindly note these words, in terms of what? The development agreement dated 26 March 2019, the power of attorney dated 26 March 2019, read with the agreement reached between the parties on 10th May 2024, which I just now showed to your lordship. There is no legal infirmity in execution of the deed of conveyance dated 27. So they are justifying the execution of the deed of conveyance on the strength of 3 documents: deed of development, power of attorney, and, my lord, not the deed of mortgage, and, my lord, this agreement dated 10th May 2024. These are the 3 documents They are saying that I am justified in selling the property to defend number 2 on the strength of these 3 documents. This has been repeated, my lord. Kindly come to paragraph. Kindly come to page 24, para 78. Para 24, page 24, para 78. It is stated that the issue pertaining to the car parking spaces and other issues raised by the petitioner is misconceived, wrongful, and incorrect. Inter alia, inasmuch as the entire property has to transferred. Presently, they are saying so. The entire property has to transferred, not the project, in terms of what was decided by the parties jointly. Now, what they say, it would be evident from the agreement reached in the meeting dated 10th May 2024 that the answering respondents would be entitled to transfer the said premises. Where do I get the said premises? Kindly note this. This is very important. My lord, on affidavit, they are saying so. It would be evident from the agreement reached in the meeting dated 10th May 2024 that the answering respondent would be entitled to transfer the said premises upon failure to make payment by the petitioner by virtue of the said joint development agreement, 1, read with power of attorney, 2, itself, and the answering respondent had a right to cause sale of the constructed space, along with the undivided share in the said land. So, my lord, now, after saying the said premises, they are saying that the power of attorney, the answering respondent had a right to cause sale of the constructed space. Yes. Along with the undivided share in the land. Yes. The project. Then how are they selling the whole premises? Retaining only 1,200 for my office. Okay. And on the basis of my lord, therefore, my lord, my submission is very.
Are still in your possession?
No, it given to them.
But the title deeds will never disclose their undivided share in the land.
No, it's 100% my share. I do not know. I do not know, my lord. I submit to your lordship that any bona fide purchaser for value would look into the right of the person who is selling a property. If he had looked into the development agreement and the power of attorney, any right-thinking person would have agreed to purchase this property, unless, my lord, this person who has purchased the property is a person who has been set up by Merlin. The Hathi is, my lord, the Merlin's property, Merlin's creation. So, my lord, Merlin is taking the property in one hand and giving it in the other hand. So, my lord, it is just change of hands. And they're taking the entire property out. This is, my lord, if I may respectfully submit to your lordship, this is atrocious. The entire property goes on the basis of the development agreement. My lord, now I have, my lord, look.
So you read out the last remaining portion of paragraph 78.
Yes, paragraph 78, your lordship is looking into. Power of attorney, constructed space along with undivided share in the land. The contention of the petitioner in this regard, therefore, on the face of it, are contrary to the terms of the joint development agreement, read with the terms of the power of attorney and the agreement which was reached by it. So, mortgage, they are not referring because they know they will be in trouble. Mortgage, they are keeping aside. I tell you, lordship, why? What they will say is this: I have sold the property now to Hatishala. The mortgage, if you have any, it has gone on to with the property. You enforce it against Hatishala. Well, I shall be moving from pillar to post for the purpose of recovery of my property. This is a very clear but dubious plot, which has been constructed, which has been built up for the purpose of taking away the property.
Okay, sir. We'll continue.
My lord, on which you will kindly not keep it tomorrow. Can it be day after tomorrow?
Day after tomorrow, কটা আছে?
আমি আমার শেষ করে দেবো কালকে।